A quorum and meeting is now called to order. Since I am of the highest precedent, I chair the meeting first. Election chairman, please. Mr. Sin Chung Kai, nominate Mr. James Toh. I second. Okay, thank you very much. I accept the nomination. And can I announce that I am elected? Yes, please. Let us invite the government officials into the room. Let me introduce the government officials. PAS, Ms. Kwan. Deputy Director of IRD, Mr. Chiu. Acting Senior Government Counsel, Ms. Ng. And Ms. Ng, Government Counsel. Okay, we have three inland revenue orders today. Let us follow the order. Guernsey, then Italy, then Qatar. Qatar, right. Qatar. Oh, let's start with the Guernsey order first. Thank you, Chairman. Good morning, members. I know that the Chairman has rich experience in studying these inland revenue orders. Let me first speak on the established policy and also the signing of CDTAs. Since reunification, the SARG has been trying its best to enter into CDTAs, comprehensive agreements for avoidance of double taxation of our trade partners. Since 2010, the EOI, Exchange of Information Arrangement, has been dovetailed with international arrangements, and we have therefore obtained a breakthrough. A few years ago, there were only 5 agreements, and now we have signed altogether 29 CDTAs. And each agreement is put before this Council under negative vetting so that the agreement can become local law. Up till now, concerning the current 3 orders, they are the they are the 8th batches, the 8th batch in recent years. With regard to the negotiation with our trade partners on CDTAs, we base the negotiation on the OECD text, or OECD version. And we base our negotiation on international standard text, and also the jurisdiction in terms of taxation has been earmarked clearly, marked out here clearly, say in terms of dividends, franchise, and interest. We have obtained a better deal or a better tax rate, I mean a lower tax rate in this regard, in comparison with no agreement. According to these international modern texts, there is also an exchange of information or exchange of tax information provision. Members in vetting the legislation in relation to EOI have expressed their views and their concerns. Therefore, we introduce our own measures to ensure privacy and confidentiality of taxpayers. In fact, this is in our legislative brief. On the whole, all along, we have adopted such measures to provide safeguards to our taxpayers. With regard to these 3 inland revenue orders, they are similar to, or they are consistent with the arrangements under the CDTAs. Earlier on this year, this Council also passed a piece of legislation on exchange of information. These 3 orders were entered into or signed before the passage of the law I mentioned earlier. In terms of tax types, they are consistent with the previous 7 batches. They are only related to income tax or related taxes. As for the new EOI arrangement, it doesn't cover the present 3 orders. I'm happy to take members' questions. Perhaps you know our various concerns. Maybe you can address those concerns and how they are dealt with in your orders. You mean the exchange of information? Yes. The first one is the Guernsey order. Under section paragraph 8A, this is reflected in Annex A, Article 24. Article 24. The various safeguards includes the receipt of a request for information. We will only provide information upon request, and the information asked for should be foreseeably relevant in relation to the relevant taxes. And after they receive that information, that piece of information, they should keep the information confidential, and the information is only disclosed to the relevant tax authorities. As for Guernsey Island, in our negotiation, we tried to limit the disclosure to the tax authorities as far as possible. But if there are reasonable grounds or if there are legitimate reasons, the information can be released to their oversight body, but this has to be spelled out in the provision of the agreement. In terms of Guernsey Island, it specifically asks for 2 oversight bodies to be eligible to receive the information. And you may refer to Annex A, the protocol. The 3rd paragraph in the protocol, they think it is necessary to pass on the information to the departments that deals with internal audit. And under administrative review, Guernsey law, hearing may be involved, and the information will be limited to a hearing in respect of taxation matters. This is an administrative review arrangement, a review on the decision of the administration. Y241.
Article 1點解要咁嘅？
Article 1.
照話應該係 restrict to Article 1嘅係嘛？
其實咧，
So why is it so strange? According to the OECD model text, this is a mutual tax agreement. So it is applicable to the residents of the contracting parties. Under the OECD, it is not just restricted by Article 1, but also an Article 2. In entering into agreements, usually we cross out an Article 2 so that the agreement only applies to the residents of both one or both contracting parties. Yes, I know that. Why it is not just restricted by Article 1? Perhaps the IRD representative can speak on this. Chairman, concerning the OECD text, the wording is not restricted by Article 1 and Article 2. We cross out Article 2. So it only applies to the tax types in the agreement. I understand this point. Why not restricted by Article 1? Generally speaking, the agreement applies to the residents of the contracting parties, but the exchange of information may not just be restricted to the information of the residents of the contracting parties. Oh, I see. You mean the information of the residents, not the information of the residents only, but information of a third party. Right. Does it spell out here the following? Say, let me put it this way. Say, suppose that is a resident of another country. He is not a resident of Guernsey, but he goes to Guernsey. The investigation is in relation to that resident. And can this law apply? Chairman, say if somebody is a non-resident of Guernsey, just a visitor of Guernsey, and has done something which is suspected by the tax authority, then the tax authority of Guernsey Island can obtain information from Hong Kong if Hong Kong has the information. Then Article 1 becomes meaningless. Now it says, the agreement shall apply to taxes on income imposed on behalf of a contracting party. Say if a non-resident went to Guernsey and had a good time for a few days, and then Guernsey Island discovered that person had avoided tax and tried to obtain information from us. Isn't it reasonable? Isn't that reasonable? Why Article 1 just mentioned residents? There must be a principal and non-principal. In fact, the agreement applies to residents of both parties. There are a lot of interests arising from taxation, and these interests can only be applicable to the residents of Guernsey Island and the residents of Hong Kong. As for exchange of information, the scope is broader. Exchange of information can cover non-residents. The tax exemption apply to residents only. Right, I know. But you put it in Article 1. Unless you say benefits of agreement apply to residents. At the start you say it only applies to residents, and later In Article 24, it doesn't apply to residents only. People will have confusion. Chairman, I take your point, but we have to base the agreement on the international model tax. Yes, probably we have overlooked that. Ms. Kwan, concerning other issues of concern, do you have anything to add? No, nothing more, Mr. Chairman. I have several questions. Article 15, Director's Fee.
Other party， 咁即係舉個例，如果香港嘅董事
In other words, if a director of a Hong Kong company pays, or rather a company pays director's fee to a Hong Kong resident, that resident may be a Guernsey Island resident as well, and we can tax that person. But have you solved the problem whether that person is also subject to tax of Guernsey Island? Now, if we pay dividend to that resident, and if he is taxed by Guernsey, that will not get any benefit for him. We can tax him, and then he should be exempted from tax by Guernsey Island. Why? He can both be taxed by us and Guernsey Island.
Article 15. This Article 15 is an international text. It means that if a person is in the place of residence of a company, say the company was set up in Hong Kong and he's a Hong Kong resident, of course, Hong Kong can tax the director's remunerations. But if it happens that the person is also a resident of Guernsey, then Guernsey Island has the right to charge its residents for its remuneration from a Hong Kong company. In other words, Hong Kong and Guernsey Island can charge the person tax for his remuneration. This is the sharing of taxing right. According to this article, Guernsey is obliged to, on all the tax charged in Hong Kong, offer reductions, tax reductions. This is mentioned in Article 21. So the elimination mentioned there includes director's fees. In other words, this is not listed in Article 15. It is listed there instead. Okay. And Article 19 concerns students. It says that if a student, you want to send money to your kid who's studying in Guernsey Island, then that won't be taxed because it says that provided such payments arise from sources outside that party. But let's look at an example. Say a friend of mine is running a business in Guernsey Island, and he is supposed to look after my child, providing accommodation, food, and I pay for that. Does it mean that would I have to be taxed? Is it pursuant to an agreement? If it's pursuant to an agreement, I may not send actual cash to the child, but I would not remit money to the island. Would that be taxable? Yeah, Chairman. Article 19 is also based on an international text. It means that if a student that is there for the purpose of studying, and if there's any support he gets for his education, and all this monetary support does not come from someone there, then the island has no right to charge any tax. Look at the Hong Kong example. Article 29, in the context of Hong Kong, well, Hong Kong would not charge the person either because Hong Kong only has income tax. But what I meant is, here it says arise from sources outside that party. You know that often, say, if you want to look after children, sometimes a company may remit money for that child, and expecting the party in the other company, where in a place where the student is studying, to pay for his expenses. Well, it depends on whether the source is in the island. If we find that the money transmitted from Hong Kong to Guernsey Island and then the money is sent to the child, then it's very clear where the source is from. But why didn't we remit the money to the island? Well, we'll look at the source still. If it's come from Hong Kong, then the source is Hong Kong. Here it says payments arise from sources. It seems the definition is quite narrow. I think source is a broad term. You can't just say whether it's remitted into the island or not. You have to look at the fact. Why a sum of money is available to the person. So you think that in this case, the scenario I mentioned can be covered? Yes. Chairman, I'd also like to point out that if both parties, for example, when Guernsey Island enforces its taxation laws, should there be any discrepancies in views, we can, through mutual agreement procedures, to resolve any possible disputes. Yeah, honestly, my impression is that some of my friends with businesses on the mainland, and they, well, it's rare for people to study in Guernsey Island, but I don't know whether I can use similar terms here elsewhere in other contexts. For example, there could be a chance that the money may not be necessarily be remitted into a country. Money can be just forwarded to another party. Overseas Chinese, for example, people with business on the mainland may just actually send money or forward money to another party to support the children's education instead of formally remitting it to the country. So, but you say that if there are documents showing that where the payments are from and for who it's sent to, then it's okay. Sometimes for tuitions can be very expensive, to the tune of hundreds of thousands of dollars a year. So maybe in the future, you think that if you think this clause is sufficient, then it's fine. But you can look into it. Yes, I will make it clear, make this point clear in our future negotiations. Other questions? For Guernsey Island, it has a population of 7 million. Just 70,000 people there. I know before the handover, can anyone with the issue with the British passports before the handover go to live in Guernsey Island? Chairman, Guernsey Island is part of the Commonwealth. It has its independent administrative, judicial, and law enforcement bodies. Theoretically, the Queen is head of state. The British Queen. Population is very, very small in Guernsey Island. So the people there, they have British nationality. Economically, well, Guernsey Island is related to Hong Kong. I know there are a lot of mutual funds registered there. But I want to ask about the people. Hong Kong residents with passport, can they live there? Before the handover, you mean the BNO passports? Yeah, there are hundreds of thousands of Hong Kong people with a BNO passport. Can they live there? Well, Chairman, well, he's not from the immigration department. Yeah, I just want to know who will be covered by these articles. Well, these articles cover residents in Guernsey Island. But I think the IRD can ask that question on your behalf. So simply put, from the revenue perspective, apart from those with mutual funds registered there individually, what kinds of Hong Kong people would have more ties with Guernsey Island? Can you provide us with such information so we can know better who can benefit from these provisions? But anyway, I have another question. For example, say someone has British nationality but has not lived in Guernsey. Let me put it this way. Is there a strict definition for residents? For example, say he's lived there for some time. Will he be given residence right then and then be subject to taxation? Well, I think the concept of residence is actually governed by immigration regulations of a place. In Hong Kong, basic law has clear definitions of who are Hong Kong permanent residents, who has the right of abode. As for revenue or taxation ordinances, sometimes depends on the number of days you've spent in the territory. That is 180 days a year and 300 days in 2 years. How about their definition? In common law jurisdictions, their residency regulations vary. But as far as you know, for the purpose of this law, are we talking about permanent residence here or just temporary residence? I think in terms of taxation, they define residents as people who constantly live in Guernsey, to the effect that that person is obliged to pay tax according to the laws of Guernsey. Article 4 actually spells this out. Article 4. Yes. (4.1a), yes. We can refer to 4.1a, the broad definition there. I think the crux of the issue is, my understanding is, people there hold British, people on Guernsey hold British passports. So under what circumstance would they be considered residents of Guernsey? Say, a British person, if he goes to Manchester or Liverpool, well, he can go there anytime. And there's no such definition of as resident of Manchester or Liverpool. But how about people in Guernsey? Because you have to apply the law to them. Well, in 4.1a, it says that under the law of Guernsey, in other words, they use domicile residence, place of management, as defined by the law of Guernsey. As Mr. Chiu said, in the Commonwealth nations, normally speaking, people have to have stayed in a place for 180 days in a year. If the laws of Guernsey follows the standard of the Commonwealth nations, then if you have fulfilled the residence period required, then by reason of your residence period, you will be defined as its resident. That's what it says. But I don't understand the last sentence, 4.1a, where it says does not include any person who is liable to tax in Guernsey in respect only of income from resources in Guernsey. Well, the last sentence here points out that for a non-Guernsey resident, if because he has income currency, if he's liable to, because he makes his earnings in Guernsey, but he's not a resident there, even though he pays tax, that means he doesn't have domicile, and neither does he have the place of measurement there. And even if he has to pay tax, he would not be defined as a resident of Guernsey. That's what it means, right? Yes. Our case falls under B2, our usual definition. That's our usual definition. Okay, any other questions? If not, let's go to Italian Republic. Ms. Kwan. Thank you, Chairman. For the Italian Republic, in the electrical brief, we mentioned the safeguards raised in response to members' concerns, and they are included in paragraph 10 of the electrical brief. And all these safeguards have been actually incorporated into Article 25 in Appendix A. Article 25. Are there anything special here? Yeah, on Article 25, on the whole, it's same as what is listed before. But what's worth noting is in Article 25, there's some supplementary provisions. For example, say a few months ago, we mentioned in our submission to the school the room for adjustments in taxation categories, in addition to income tax. In the past, we tend to focus on income tax, but there is an agreement reached in the negotiations with the Republic, but they want to include the possibility that in the future, should Hong Kong enter into any agreements with other jurisdictions to expand IOI categories to taxation items, to additional taxation items, then Hong Kong should also negotiate with the Italian Republic so that they will be given the same treatment.
Is it in the agreement? No, in the protocol. It is part of the order. Where is it then? Part 2 of the order. Page 72. Page 72 of the order.
哦 ，OK， 即係佢喺個 Part Two 嗰度。哦 ，OK， 係。
This is in Part 2.
咁樣啊 ，OK。
Oh. Okay. You refer to Article 25, and apart from this, there is nothing departing from our previous practice. Now concerning 25(4), what do you mean? Now, in 2010, before the change of law, in exchange of information with other jurisdictions, we are restricted by whether there is any domestic interest in such information or not. But after the change of law, if we don't need such information, that cannot be an excuse to reject the demand or request for such information by our partners or counterparts. Now, you mean with regard to the agreement signed after 2010, this provision has been included? Yes, broadly speaking, that's the case. They need a special provision to clarify this. They know that we had such a restriction in the past, and if they require such a piece of information, we'll help them. Say if they request for such an information, yet because of that piece of information is not of domestic interest, you still have to make use of the powers under the IRO to obtain such information on behalf of that authority, that overseas authority. Of course, it has to be in line with our own system or law. Say, for example, Mr. Chiu, say if it is against a taxpayer or an associated party, the information asked for the letter asks for information exercising mandatory power. Is it just entirely for the implementation of an agreement or tax exchange of information agreement? Now, when we receive requests, they have to provide the information. We say if we are satisfied of that request concerning the request itself is served upon the person so as to obtain information according to the IRO. It is not for local tax purpose, but for collection information on behalf of an overseas authorities. Do you mention that in your letter? Well, when we ask for information, we issue a formal notice, which is a template. We spell out the relevant legal provisions. The legal provision is, say, a certain section under IRD, but that also mention that letter also mentioned, notice also mentioned the information request under the tax agreement. Yes, you have a special clause. Yes, indeed. So the person who reads the letter knows that it is not for domestic use. It's based on tax agreement. Do you mention the originating country? Usually we do not. I think you should mention the originating country, the country where the request originates. You need to enable that person to be prepared for any litigation in that country. Say, for example, I may be subject to a tax of 10 countries. Guernsey is not, it may be Guernsey or it may be Italy. So if I know it is Italy, then I may prepare differently if it is, instead of it is from Guernsey. Now, when we provide information to the overseas authorities, we need to have a copy, send a copy to the party concerned before we deliver the piece of information to the overseas authorities, so the person knows. Now, my question is this: do you have a policy restriction or a certain restriction under the law or a certain restriction under the agreement that you cannot disclose the originating authority. Now that may be just a gift, but for the person concerned, it may be very crucial. If one doesn't know which country is asking for the information, it will be problematic. It is problematic. Chairman, I think there are 2 points here. Say the person may be a taxpayer. The subject of may be a person, but the information is from the bank. Say there are 100 countries. You asking for information, you can say that according to the agreement, 100 countries, such information is provided. I think you should give the first available time to that person if he needs to take any action to prepare himself. We have the notification system, but you say upon the delivery of the information, when we receive the request, we inform the person concerned. The person concerned, say, it may be a certain party. The person subject of that investigation. You may obtain information from parties B, C, D, E. They may need to protect certain information. Now, if it is the subject of investigation, say A will inform A. But when you get information from B, you also use your power. You ask information about A from B. Shouldn't you inform A that Italy is seeking information? We have to do it under the tax agreement. Is there a policy or a law that restricts you from telling party A that Italy is seeking information on him? According to international practice, the obtaining of information and also the provision of information is done with confidence. We cannot disclose the information, or we cannot disclose that request to a third party. Say, suppose you need to inform A. Why you cannot inform B, C, D? According to what principle? Now, in implementing the agreement, we have to keep the act confidential. And that's also good to the party concerned. It's not about party concerned. Say whether B is a trading firm or a bank, that company may have relation with the requesting country and it has to protect its own rights. Now, if the law prohibits you from informing them, we can do nothing about it. But suddenly, if I receive a letter from the IRD asking for information, I have to give the information. But I may have a way out, and to protect my rights, I can't just fight it in a court. I don't understand. Chairman, if I may add, say under if we collect information on salaries tax, profits tax, and property tax or property tax, in collecting information we try to be confidential. It is directly related to me. I can fight it in a court with you. But I don't know. But in the collection request for information, I really don't know where is the originating jurisdiction, and I really don't know where to fight for it. The only thing I can fight with you is that I ask for the disclosure of the originating jurisdiction. Now, give me a paper why you can't disclose the originating jurisdiction. In terms of, well, we may say the BCD is not innocent, but you use your power to get information. You claim it's from an overseas country, but there are so many countries in the world. I may not be related to that country. There is no reason for that country to seek information about me from the IRD. But if I'm not informed about that, then I may be disadvantaged. Mr. Chiu, do you understand that? I'm a councillor. I try to protect the interests of certain people. Now, the IRD is responsible for collecting tax. You may think you need to protect the interests of that country. But for me, I give priority to the interests of the people in Hong Kong. If the person just doesn't know where should he fight his case, then there is no protection. If you give him adequate information, then that is fair to him, and he shouldn't complain. Say, suppose there is a contracting party asking for information of Mr. A. The information is about Mr. A's information in Hong Kong Bank. If Hong Kong Bank has information about A and is entirely on A, then upon request, we immediately inform A that we receive a request from a contracting party asking for the provision of information of your Hong Kong Bank account. Before we provide information to that authority, do you have interest in seeing what information we're going to provide? That's for A. And then we inform B, Hong Kong, i.e. Hong Kong Bank. We've received an agreement. We have received a request from a contracting party, and we obtain information. And that's just that. We don't provide information to other information to Hong Kong Bank. But there are trade partners, business partners, or fellow directors of Mr. A. It's not just Hong Kong Bank. Hong Kong Bank does not need to know which country is going after A. Say if I make a payment to A, not to Hong Kong Bank. Say I own a company, I'm concerned why the IRD wants to get information of A from me. I may not be willing to provide information, and I may dare to go to I may go to Italy to fight the case out, to fight the case with the Italian government. Chairman, I just give you an example. I agree with you. The information asked for may involve B and A and B as well. The notification system will cover B.
Mr. Chiu, I'm talking about that, if you ask me for other person's information, you have to think about it. If you think the arrangement is fine, please let us know why, if not. To me, this is something very important. Of course, there could be a fallback. That is not automatic. For example, there's so many Hong Kong banks. Can you consider that if someone who asks for information, and tell me which country he's from, so that can save your administrative work. From my perspective, I hope you can consider Hong Kong company, Hong Kong people under the taxation law who are required to provide information. There are circumstances where he needs to have his right protected. Do you know what I'm talking about? I do know what you're saying. We need to be careful with this. But as I said just then, the example I cited was about information about A. I'm not talking about a bank. Let me give you an example. You keep thinking about banks, but I want to adopt a much, much broader perspective. I've seen similar scenarios. All of a sudden, people come here for information, and you have no idea where these people are from. we do have a notification system. Yeah, but your notification system is about A. Well, Mr. Chiu, I think you're worse than ministers, government ministers here. I hope that our minds meet. Please answer what I was asking and not repeat what you have said. Chairman, let me supplement here. In the past, conceptually, we're saying that in enforcing the agreements, the department, even though it has to get information from BCD or trade partners, not necessarily banks, for information, firstly, he needs to, first of all, satisfy the overall requirements, that they must be relevant information. And we also need to, from BCD perspectives, I'm very worried. Mr. Kwan and Mr. Chiu, you keep saying that you are officials and you say that you have to be accountable to the country. But as a member of the public, I often receive cases or requests for protection of their rights, taxation rights, overseas and here. People are afraid. They want to have the cases settled, but I need to know where does the request come from. I'm trying to convey to you the need to protect their rights. We need to let them know where, which countries are involved in the case. So you need to let me know what countries are we talking about. So it's not just about Hong Kong Bank. There could be all kinds of rights involved. New files can be opened. So maybe even case B, maybe a company thousands of times bigger than company A. And he may actually give money to A for lawsuits. I've seen similar, very complicated scenarios, and there are mainland elements, and sometimes the situation can be very, very complicated. But as a matter of principle, please, can we let them know what country is involved? Then that party can get legal advice in that country. So if someone asks Mr. Chiu what country it is, then can you tell them? Yeah, Chairman, I will consider your proposal, but let me point out that when enforcing the law or agreement, sometimes there could be technical difficulties. For example, using the example of A. A may not want to disclose his taxation information, including his investigations upon the overseas. According to Guernsey agreement, then information is relevant, then the bank may know that case A is under investigation in Guernsey, and this is not what we want to see. Let me tell you then, can you think about a system? I know that, say for case B, you may want to tell case B that Germany wants information about case A, and case may be upset about this. And you may tell case A that now you've received the information that case B, ask whether you object to it. And then case A can let case B know if he objects to revealing the information. So that's inter-party lawsuit. Things can be very, very complicated on earth. If there are disputes between case A and case B, then they can settle them among themselves. But if case has no objection, then case B should be allowed to protect its rights. Please put these points down in your paper. I hope that when you think about the situation, judging from our conversations, I really feel that the government is very bureaucratic. Only thinks about protecting the system and the smooth operations of the agreements between countries. But I'm thinking about various parties who, because of your enforcement of the law, can't have their rights protected, not even knowing, not neither can they know which country is involved in the case. Especially for large companies, who are having businesses in a particular country, they need to actually resolve the case as soon as possible. I'm thinking of many people in Hong Kong with companies whose interests need to be protected. I hope that you can strike a balance. It's not just about taxing people to get income alone. Colleagues, any other questions on the agreement with the Italian Republic? If not, then let's go to the last one. State of Qatar. Ms. Kwan. Qatar agreement in our electrical brief, paragraph 7, it lists safeguards. And they are translated into Article 25 in the appendix. As in our previous agreements, the content is similar. And on this Qatar order, there are actually no other points that I need to highlight. So, yeah, just standardized provisions. Article 21 is the other agreements have the same provisions here in relation to other income. Oh, yeah, Chairman, this article is based on the international text model copy, and if there are to be basically Article 21 spells out the definition for other income. This is actually in relation to items of income of a resident of a contracting party. Say a Qatar resident. Qatar, do they charge global tax? No. Normally, say a country charge taxes all kinds of income, including gains from lottery, Mark 6. So other articles will cover that. And these other income would come under Article 21. So if if this sort of taxation is included in the taxation rules, then these other incomes would come under this article. So this is a standard provision. You can look at it as a residue provision. Say, for example, many Hong Kong companies issue dividends. If are dividends dealt with in many agreements? No, we do have a dividend article. In Qatar agreement is in Article 11, 10 and 11. Say a Qatar resident, say he opened a bank account in Hong Kong and bought some shares and regularly given dividends. So the Qatar residents, well, Qatar residents are not liable to Hong Kong tax for the dividends received in Hong Kong, because the decision right belongs to the residents' place of residence. So I think some shares now, Prada, or shares issued by Italian companies here. Before we received dividends, I remember I heard that the dividends are issued with reduction for Italian tax, same as China Mobile. So last time in the Italian case, say if is an Italian resident who lives in Hong Kong, Italian resident who lived in Italy, Italian in Italy, Italian who lives in Hong Kong. So would he have to be taxed for the dividends again?
You say he is an Italian resident, then that Italian resident will have to pay tax according to the Italian tax law. If a Hong Kong resident receives dividends from an Italian company, then Italy has the power to collect tax. According to Italian law, dividend, the withholding tax is 20%. With this new agreement, withholding tax is cut to 10%, and that is beneficial to Hong Kong residents. It is as for Hong Kong residents, they receive more dividend, net dividend. Say, for example, I hold Prada, the stocks of Prada. Prada gives out dividends. An Italian lives in Hong Kong. He received less net tax, right? Net dividend. Yes. In fact, Italians pay a higher tax than the Hong Kong resident. It involves many voters who hold Prada or other Italian companies listed in Hong Kong. Now, basing on this tax agreement, what can we do to pay less withholding tax? Do we need to write to that company, say Prada, or do we need to write to the Italian government in order to cut the withholding tax liability? It is a procedural matter. Different countries may have similar practice. Usually the tax is withheld, and then you need to claim a tax rebate by filling in a form. Mr. Chiu or Ms. Kwan can help. Now, if we pass the order, if that is such an implication, you should make it known to the people. People may have held Italian stocks, and they could get a tax relief. Well, you still think that your web page is okay, but you just signed an agreement with Italy. In fact, the financial commentators mentioned the withholding tax several times when Prada or other Italian companies were paying dividends. I think it's good for the IRD to do a briefing so that the community will thank you. This is a very good thing. You help them to get some money back. They really don't know what the piece of law means. They don't know what the piece of law means, but if you explain it to them, then they will be grateful to you. Yes, indeed, many people ask us about this. Yes, please do something and tell the media. that will be cut by 50%. Yes. Is it just the withholding tax or the final tax? As for Hong Kong residents, 50% of the withholding tax. Now that's a big sum, right? Oh, yes, indeed. They are quite reluctant. Okay. In return, they may find the other parts of the agreement very important. There are several stocks, Italian stocks, listed in Hong Kong. The brand names, cosmetics firms, but a few Hong Kong firms are listed in Italy. I think none, Mr. Chairman. Okay, back to Qatar. Any questions on the Qatar order? Okay. Before we complete the scrutiny, please issue a paper on the provision of notification, and then we decide whether we call another meeting or not. Otherwise, if we don't need another meeting, then we'll go to the House directly. Well, we need to know when Prada gives dividends. Once the order is passed, you can call a press conference, right? Usually, the orders have to be enacted into local law, and then there should be mutual notification before they come into effect. Do you need a commencement notice? No, we don't need. We have already set our date. We wait for them. Good. We will extend the scrutiny period to play safe. What else? Okay, so be it. Meeting adjourned.